the notes, this type of notes, they are very, very well summarized. So personal security, as I've said, is a type of a security. It's not type of a real security. There are two types of security. We have a real security and personal security. Therefore, you must never forget that when you get into the examination. This one, personal security, deals with the suretyship, and then where someone decided to be the one to pay for another person. The real security, yesterday I sent you about the pledge, and then I give you even some of the many examples about the pledge, so that when you get into the examination, you will remember that, oh, they said this one, they said this one. And then I told you that one thing that you must see the pledge is that only movable property can be delivered as a security by the pledger to the pledgee. It means that only movable property. It means that pledge uh, does not work on immovable. It's only when they say movable. Only when they say movable. And don't forget that. But the thing that I want you to know well is that you must know how to answer questions about the pledge, and how to see that this question is about the pledge. I gave you some many um, many examples, and this one of a Gloria, I was giving you that if there is no delivery, if you said that you will deliver a car and then you fail to deliver that car to me, there is no pledge. It means that is what is a personal right. It's not a pledge. Therefore, if you come to me, we agree, said, can you borrow me 8,000? I will deliver a watch, so that you'll be having a watch as security for the debt. I give you 8,000. You fail to deliver a watch. It's not a pledge. It's a personal right. For that one, you have to deliver a pledge. And another thing that I try to answer so that you know about this one is that one of saying that no, uh, I will deliver the car, but I still have like this one of a gym. I still have to take my children to school, so I'll be using it. But you have that car. No, you don't retain the control of the car. You have to deliver such a thing. You don't retain the control. So we call this a constitutum possessoria, when a person retains the control, or you give another person to act on behalf of you, and then you said that because that car is not in your control, it means that you have delivered it to me. No, you deliver the car to me, then I give you money, then we call it a pledge. Without doing that, there's no pledge. Then I also give you um, the obligations of a pledgee. Remember, pledgee, those are the words that you must use when you answer on the examination. You must use only the term pledge. Use these two terms. Do not write about a pledge and not use these two terms. You will lose mark. It's how it's you must be right. It's how people write. Is the element you use pledger and pledgee, pledger and pledgee. pledger and pledgee. Don't forget that pledgee, pledgee is the loaner, right? It's the person who gives loan. And then pledger I will just say it's the one who borrowed money so that you can use. So when you get a question in the examination talking about it, maybe talking about someone, and it's talking about the pledge, answer like that. Then if it is a question like this, let's see by this one. Okay, these are the obligation of the pledgee. By the way, a pledgee must take care of the property like a reasonable man, and on termination of the pledge, he returned back to the pledger, right? And then there was. So let's deal
So
with
didn't we mix them in the explanation? Is the pledger not someone who borrows, who gives?
pledger. I don't understand.
Oh, okay. No, I'm getting it.
I mean, a pledger is someone who borrows. The one that when
Who borrows?
borrow the money. The pledger.
The pledger is someone who borrows, and the pledgee is the one who receives.
I don't think that you are understanding the pledger and pledgee.
Okay, sorry, say, can I at least make it simple for her to understand the pledgee and the pledger?
Oh yeah.
Okay, when you say pledgee, just to make it simple, you can say is the person who gives, and then the pledger is the one who receives. I think that way it will be much easier for you.
Oh yeah.
Do you understand me?
Okay. No, I think I understand it. I think I was more looking at it as someone who, I don't know, maybe I'm looking, I was trying to refer to it in a manner in which when we talk about other terms, the G and the fornication, not fornication, like phonetic. I forgot what it's called in English. So that's why it was a bit confusing me when you let's give an example of a mentor and a mentee. So I was looking at it in that context. That's why I was getting confused.
An
Oh,
employer
yeah,
and employee.
Employee as an example, yes.
And then right now, do you understand me when I say pledgee is the one who gives and then pledger is the one who receives?
Yeah, so it's sort of vice versa when you looking at the other examples that we generally use. So I must just remember those definitions. Yeah.
Yes, even trainer and trainee.
Yes.
I get that.
Yeah.
I get that.
That's why I was a bit confused because I thought, the pledger would be the one who loans and the pledgee will be the one who actually receives. So it's the other way around in this context. Yeah.
In this way, it's like it's
It's opposite.
opposite. Yes,
Yeah.
that way. Let's
Yeah.
go proceed this way.
Yeah.
Okay,
So you understand why I was getting confused, Mr. Mnyang?
Oh yes, now I understand that you were thinking of mentor and mentee, and many people have this
An
confusion.
employer and
That's why.
employee.
Yes,
Yes.
so pledger is the one that borrow money, and the pledger is the one that who must deliver the security for the debt, just like a Jill who said that he will deliver the car and never deliver. So he said Jill was a pledger, and that is a scenario, and the pledgee was Matilda. So now you know pledgee. So you must never forget to use pledgee and a pledger when you answer the question of a pledge. You can lose mark for that. So you must always remember when you get into examination. If it is question of a Samuel, it means that you will say that Samuel is a pledgee or as a pledger. Normally, you must answer like that. Samuel is a pledgee or as a pledger. That because Mary has loaned Samuel, it means that Mary this. You will say that. Mary as a pledgee does not have a right to use or enjoy or alienate the property. Then that's how you write. Mary as a pledgee, Samuel as a pledger. In the examination, you must always write like that. Don't just answer without writing this term. These terms are very much important. Even that, those one of mortgager, don't forget to write those terms, mortgager and mortgagee, those two terms. But we're still gonna discuss them anyway. So I gave you all these notes. Because some people always say that in the examination they are seeing some of the new things. They've never learned about such a thing. Yes, maybe it can happen because maybe you don't have a notes for such a thing. It does happen. Remember, some study guide is not doesn't cover everything. So we talk about the liabilities in the according to the National Credit Act. People who are doing sale, law of a sale, they are dealing with a National Credit Act. Therefore, they know about this National Credit Act. They know about these liabilities because they are dealing with it with them on a law of a sale. If you choose it, then you will deal with this one. And then we have a right of a pledgee. And I written one question down which you must not forget when you enter into examination. I did that so that you will never forget. They said on the study guide they do talk about insolvency, but they never be straightforward about the insolvency. So you must never forget when you get into the examination what happened if then someone is owing you, then the next day the estate is sequestrated, is insolvent, the estate is sequestrated. It means that you as the pledger, if the pledger estate is sequestrated before you get your money, it means that you have a remedy in terms of Section 95 of the Insolvency Act. Don't forget that because they can come with such a question. And you may find that you can't see it on the study guide. But yes, the remedy in terms of Section 95 of the Insolvency. Another issue is the issue
Sorry,
of
sir. What did you say? What is the name of that remedy on that section?
no remedy of a preferential claim. Yes, a person or a creditor has a preferential claim under Section 95 of the Insolvency Act. We call it a preferential claim. If you have done Insolvency Act MRL 3701, it means that you know about this remedy. If If the estate is being sequestrated and the person is owing you, you have a right in terms of Section 95, a preferential claim, so that when they sell everything, you'll be the number one to be preferred, so that you're able to reimburse your money. Don't forget that on this note that I sent you. And then I also give you another question that I think that is also important. What if the person who have to deliver the car, then take a car and deliver to another person? What must happen now? It means that there is a principle called prior tempo, which is applicable. It allows you, a pledgee, to go and claim such a car, then it will be returned back to that person until such a person pays. And then I ended up by answering that question that we were talking about, the question of a lion or lien. What happened if he improves something of a pledger, if he improves his car or anything in terms of the contracts? Someone comes to you and said that, repair my car, I will repair my car, and then I will come and pay you. And then maybe you are repairing or you are improving, and the improvements maybe it's 100,000, and now the person is no longer paying. What must happen? It means that you must claim enrichment, unjustified enrichment. It can be creditor, it can be debtor to creditor, or it can be normally unjustified enrichment. We have, I believe that I've sent you those notes of the unjustified enrichment. So don't forget this one of a pledgee can institute an enrichment claim against pledger for all necessary expenses. I told you about the luxury expenses. There's no claim for luxury expenses. Therefore, if you take money and then you use it for luxury expenses, therefore you don't claim such a thing. Never forget that luxury are not the one to be claimed. I hope you know about luxury expenses. Okay, let me give you some terms. Luxurial or luxury expenses. Number one, let me just give you by vacation. This is when people go on the vacation and then they are having fun. That is a luxury. Or you buy a watch, or you buy a paint, then you paint somewhere in your house. That is a luxury expense. Then such a thing cannot be claimed that I bought it. I went to vacation. Uh, when you buy yourself a watch and others, jewelry, then those one are not parts. So don't forget, guys, use these notes. They are very, very, very important notes.
Vasco's dry cleaners, or is it Tyco's dry cleaners? I don't really understand.
Vasco.
If you scroll up,
You mean which one? You mean this one?
This one, yes, that one. The Vasco dry cleaners. I just want to, what is the decision whether a pledge can be created by a constitutum possessorium? What was the decision of the court in relation to this case?
That they cannot, the constitutum possessorium cannot be part of the delivery. Remember, when we talk about the delivery, we have talked about the delivery of the movables. Remember about how the movables are delivered. We talk about
Yes.
symbolic, but symbolic does not apply here. We talk
Yes.
about delivery with a short hand, delivery with a long hand. We talk about something like a custodium, possessorium, and others.
Yes.
Yes. So the court here on the Vasco dry cleaner emphasized that a constitutum is not part of the delivery, cannot form part of the delivery for the pledge, because it can lead to a fraud. Lead to a fraud. If you don't understand what is this one, okay, let me show you. So, constitutum possessorium is when you go and buy. For example, let's just give example by BMW. You go and buy a car from the BMW, then they return control of the car. You left it there, and then you come back. It means that it's a constitutum possessorium. It's when that you discuss that I've bought such a thing, but the person retains the control of that. It means that in the agreement, the pledgee and pledger will say, the pledger will say, okay, I'm delivering the car as security for the debt, but because I have to fetch my children from school, I'll be fetching my children from the school using the car. So, but the car will be under your ownership. It means that in that case, here it doesn't apply, because there was no actual transfer. So when we deal with pledge, we deal with the actual transfer. So in the Vasco dry cleaner, they said that this one constitutum possessorium, because there is no actual transfer of such a property to another person. Therefore, it will lead to a fraud, and it doesn't apply to a pledge. Therefore, this one is an odd one out when it comes to pledge. But this delivery with a short hand and others can apply.
So now, at the end, the court decided that the true substance of the contract was one of the pledge, although it didn't happen.
Yes, they went to court because the pledger was still in control of security. Remember, the person never handed, because said that I'm still in control, but I have handed through constitutum possessorium, meaning that we have transferred such a property through an agreement. We agreed that we are transferring, but I will retain the control in that process. So it is a possessor, it's a constitutum possessoria. It doesn't apply. So even this case, I took it from the study guide, is the Vasco dry cleaner.
Okay, no, that's fine. I'll read further about it.
Yeah, read further about it. No problem. Okay, let's move on.